This is Anne Grant. Custody scammers find Robin Yeamans' smile as scary as her mind. At the Battered Mothers Custody Conference on January 9, 2011, I had an opportunity to ask Robin about due process violations in custody cases.
There are two kinds of due process. Generally, people are talking to me about procedural due process, so that I just had a case where the judge looked through the court file and made a custody order without notice, hearing, motion, evidence, cross-examination, anything. That would be your classic denial of due process. Oh, and it also occurred while he had stopped discovery, which is also a part of procedural due process. The key thing in procedural due process is notice and the opportunity to have a hearing and prepare and present a case. There is also some indication that the right to a record is also a component of due process. So that's procedural due process, and it happens all the time. And I actually have been to the United States Supreme Court on an issue of due process. Of course, they didn't grant a hearing. They were busy hearing Anna Nicole Smith or something and didn't have time for us. The other form is what you'd call substantive due process, which is more difficult. And that's arguing that what the government is doing is completely irrational, so that if a person is criticized for being an alienator who's trying to interfere with the parental relationship, and you respond to that by completely cutting off mother's relationship with the child, that is completely irrational. And so I have a brief I've done on substantive due process. And what happens typically in the cases of the denial of procedural due process, at the beginning of the case, without procedural due process, the judge makes an order for custody. Boom, kid's got to go here. And then that happens with the speed of light, speed of lightning. And then the case goes on slow boat to China, and you get to trial maybe a year or two later, and then the trial judge says, oh, stability is good for children, and this is where the child's been living, so I'm going to essentially rubber stamp this order, which we know was made without due process. And so the non-due process order takes on a life of its own in the form of stability. And that's a very typical form for these cases to take. So those are the two, the procedural, the substantive, and the most usual manifestation of procedural due process that we see. Equal protection is extremely much harder. I don't really recommend it as a remedy. I do feel that, and it tends to manifest itself in the treating things that are different as if they were equal, so that a good example is trying to use it in terms of free speech. Is free speech by the KKK the same as some black person who makes an anti-white statement? Well, the KKK in our country has a history of lynching, murdering, and everything else, so the two groups are not exactly in the same situation, but the courts treat them as if they were absolutely equal. So I see treating things that are not equal as equal is a problem. In the court area, what this means is you treat mother and father as if they were parent unit 1 and parent unit 2, and they function in identical manner, and you act as if emotions and feelings and attachment are nothing, and then the evaluator looks at parent unit 1, who happens to be female, parent unit 2, the male, and decides that in the abstract, he thinks the skills that Parent Unit 2 have are better, and so they put the kid with Parent Unit 2, totally ignoring the relationship. In general, the equal protection clause has been really, really, really hard to apply. Oh, and that was the treating two different groups as if they were equal. The more usual form of it is treating two groups unequally so that heavier burdens are put on the mother, so that if the father visits, it is seen as it's so wonderful and he's trying, and if the mother does the same amount, it really doesn't amount to anything. So we see heavier burdens constantly imposed on the women. However, as a matter of historic reality, relying on the Equal Protection Clause is just much harder. The judges don't see the inequality, and they are much more likely to see, let's say, procedural due process than they are to come down on the equal protection issue.
How do we prepare these cases to take them to the federal court?
Well, of course, your first problem, now, I don't usually practice in federal court, although I'm qualified to go to the U.S. Supreme Court. But what you have to do is you have to go through your state court, and you have to go in a timely manner. I cannot advise you on class action. All I do is divorce. But I would say a key thing is you gotta move it, move it, move it, and if they get old, then it's not gonna work out. I would be more likely to think that you could get 4 simultaneous divorce cases going than a class action, which because the courts are in the hands of corporations and business, and that's who is hurt by class actions, the courts have whittled away at the ability to make a class, and you might want to think of a small group of litigants rather than individual litigants rather than a class, but I am not one to advise you on that. It was a little impromptu.
You are amazing. Why aren't you a judge? What's California doing, not getting you on the bench?
Well, one of the things is that they require judges not to make public statements about cases that might come in front of them.
You're not going to the Supreme Court now.
So it would gag me if I were a judge, and I don't think I would want to do that. And the other thing is they require you to be a fan of the death penalty, and given my experience with the courts, I really wouldn't trust them to decide who to put to death.
Thank you so much.
Thank you.